Welcome back. Let's talk about the Labour Party. That despite the Supreme Court this time judgment, it seems to be more confusion with everybody laying claim to the leadership of the party. But just a quick one before I introduce our guest. Let's walk back a little bit. In 2019 also, the leader or the national president of the Labour Party had passed, and Mr. Julius Abure took over under quite controversial circumstance because then he was the secretary of the party and there's a hierarchy. But fast forward to 2023, an extension was done. They got a good outing at the presidential election and other elections as well. Well, that extension ended in June, at about June 2024. There was a congress organized in Nnewi, another controversial congress, because the argument now is that those congresses didn't follow through the right process of ward, local government states to the national convention. Where we are right now is to the effect that during the Ondo state governorship election, it was as to who is the authentic candidate between Chief Ebisani, and Olorofemi. That case got all the way to the court, and there were changes in between. But in the pronouncement of the court had acknowledged Julius Abure as the chairman of the party. What the Supreme Court decided and said, look, no court has jurisdiction over issues of chairmanship and membership. It's an internal party issue, and that has generated a lot of controversy. So the caretaker committee led by Nenadi Usman, supported by Peter Obi, Alex Oti, and literally most of the elected representatives of the party versus the Abure faction, everybody now laying claim to the leadership of the party. That's what we want to explore today, looking at the legalese as far as the issue of Labour Party is concerned. We're being joined in the program by the Senior Advocate of Nigeria, Mr. Sam Kagbo. Also joining us is Mr. Ekemini Udim, a public affairs analyst and a legal practitioner. Senior Advocate and Mr. Ekemini, thank you so much for coming on the program.
Thank you very much for having me this morning.
Thank you for having me.
All right. Let's start with you. I want to believe that you have seen the CTC, which has become a controversial issue. Well, the court has said the lower court, the trial court, was wrong. The appeal court was wrong, set aside their decision as far as the pronouncement of Julius Abure as chairman is concerned, also striking out that decision of the lower court, dismissing the appeal and saying it is meritorious, and allowed it, and even give an advice to the political party. So, you know, they respect their own rules in that sense. Well, Julius Abure says the decision of the court is to the effect that we already have a structure in place. We have a leadership, so there's no vacuum. Alex Oti, Peter Obi, and the rest stakeholders are saying, no, let's do a proper convention for elected officials of our party. What do you make of that judgment and these multiple interpretations?
Well, the judgment is very, very regular and in tandem with the general principle that internal party affairs are not justiciable. That is, dispute arising from internal affairs of the political parties are not ones that the court can entertain. That is the regular position of the law. And the nuanced position is usually that of the cases where the court can entertain the issues bordering on internal party politics. And the only narrow space given to the court is the one regarding the nomination of candidates. And that is if a party who is a candidate in an election for the nomination into an elective office feels that the party had failed to follow its rules and regulations. Beyond that, the general principle has always been that, the court should not at any and for any reason interfere with internal party politics. So the case in question actually is one that is very, very interesting in that generally, the party went to court actually to challenge an exclusion by INEC in the invitation that INEC sent out to political parties concerning the Ondo election of last November. And in between that reliefs, one particular relief was smuggled in, which is to the effect that the INEC should recognize the leadership of Abure. The court yielded to that But what the Supreme Court is saying, that very particular aspect of it that has to do with the leadership of the party is not one that the court should have pronounced upon or interfere with. So basically, that is the position. The court is right. That is the general position, and it is not the nuanced position at all. Otherwise, the other cases that have been tried by the courts and the Supreme Court has also listened to, those are the nuanced cases that are exceptional.
Mr. Kemidi, maybe your take on this particular one as to why everybody is still laying claim. They all agree that the party should decide its internal affairs. But now what is the internal decision of the party is where the bone of contention is at the moment. Abure is insisting he's in charge. And you know, according to their own laws, if you do a convention, if you have to remove the national chairman of a party, it has to be in a convention according to some of the things I saw in their law. And that convention has to be called by the person who perhaps is to be removed. So it's a bit of a controversy here and there in the legislation around the laws of the party. But maybe you speak broadly to the issue as you've interpreted it in your own view.
Well, thank you once again for having me. I have read the judgment of the Supreme Court, 48 pages of the judgment. And what I can pick from that judgment, the interpretation from that judgment, is that the Supreme Court has not pronounced that Julius Abure is still the national president of Labour Party. And the Supreme Court has not also pronounced that Senator Nenadi Usman is now the national president of the Labour Party. Why has the Supreme Court refused to make that pronouncement? Because the Supreme Court was not happy with the decision of the trial court, the Federal High Court, and the decision of the Court of Appeal. These two courts held clearly that issues of leadership of a political party are issues within the internal realm of the political party and therefore non-justiciable. That is to say that the courts would not dabble into them. These two courts held that clearly. But along the way, the courts went ahead and affirmed Julius Abure as being the national president of Labour Party and directed INEC to relate with Julius Abure, send correspondences to Julius Abure, and so on. And the Supreme Court wasn't happy with that. And that perhaps is the reason why their lordships of the Supreme Court refused to fall into the same error of making a pronouncement on the status of Julius Abure or the status of Senator Nenadi Usman. So the interpretations that is given everywhere, this one says I am the national president. This one says the Supreme Court said I am now the national president. The Supreme Court hasn't said so. Now we go to the judgment. It said, consequent upon the foregoing, the decisions of both trial courts and the Court of Appeal recognizing Barrister Julius Abure as the national chairman of the Labour Party are hereby set aside, and struck out that very judgment of the two courts for want of jurisdiction. It therefore means that the Supreme Court has not made a pronouncement as to whether Julius Abure is still the national president or whether Nenadi is now the national president. But the Supreme Court gave direction. And I think this is what the Labour Party is expected to follow. The Supreme Court gave direction in that same judgment. And what did the Supreme Court say? Let me quote, "Before I am done, may I admonish political parties and their members to endeavor to always allow their constitutions, rules, regulations, and guidelines to guide them in choosing their officers as well as candidates. That way, incessant internal rift which always find their way to court would be reduced." And the court clearly stated this. If the constitution of a political party has prescribed duration for tenure of office of an officer, such officer should be humble enough to leave at the expiration of the tenure. This is the direction that the Supreme Court has given. Now, the ball goes back to Labour Party as a political party. Has the tenure of Julius Abure expired? If it has expired, the Supreme Court has stated it clearly If the tenure of Julius Abure has expired, going by this admonition of the Supreme Court, it therefore means that Julius Abure should step aside. If the tenure of Julius Abure has not expired, it therefore means that Labour Party has no option than to allow his tenure to expire and then choose the next leadership of the political party, and that is the admonition that I think that Labour Party should take now, flowing directly, from the decision of the Supreme Court. The interpretation given left, right, and center, it's political, it's expected, political. I mean, people defending each side and the other, they will have their own interpretation. But I think that the most cogent interpretation should come from the decision of the Supreme Court, which we all have the CTC now, and the decision is so clear.
Very interesting points there. I just should follow up by naturally asking, for you, seeing the back and forth congresses, if I can call it that, has his tenure expired, as Mr. Abure's tenure?
Well, I wouldn't know whether Mr. Abure's tenure has expired. I'm not a member of the Labour Party, but the Supreme Court has shifted it back to the Labour Party. This is an internal party affair. They are the ones that conducted congresses.
All right.
They are the ones that see to the emergence of this person as the leader, as this and that. So they have to go back to their books. Whose tenure is currently running right now in the Labour Party? Is it that of Abure? If it is that of Abure, then the Supreme Court has admonished the Labour Party by this pronouncement. Go back home and then take care of that, address that issue.
Right.
But if Abure's tenure has expired, by this admonition, it means that Abure should step aside for the next person to come on board, because the Supreme Court is saying...
All right, let's go to senior advocate, Mr.
As soon as your tenure expires.
I just wanted to see if we could make headway, but in any case, you're not even a legal practitioner for the Labour Party. They're not consulting you, so what you can do is limited. That's for the Labour Party anyway. Let's go to the senior advocate of Nigeria, Mr. Kagbo. And, it looks like the Supreme Court stayed above board, right, in spite of what we saw at the lower courts. Just said, you know what, we should not be involved in this in spite of the fact that the lower court had dabbled into it. I don't know if there's going to be some sort of redress so that in the future we won't have lower courts dabbling into political party affairs. But on the flip side, you wonder, is it fair to say that they are dabbling, since it's the same political party leaders that went to the court and say, we couldn't resolve this ourselves internally, so we want the court to help us resolve this. And clearly, we've seen that it has not been resolved. So I don't know if you probably want to speak to some of the points Mr. Odim raised, as well as what will happen in the future when cases like this go back to the court, because it looks like they might still go back to the court at this rate.
Well, that would be unfortunate. But let me make a little bit of a variation here. The Supreme Court did not give directive, because if it's a directive, it becomes an order. What the Supreme Court did was to speak off record. It speaks to the party and gave a general advice that anybody can give to the political parties. That is, go organize yourself, maintain and respect your party constitutions and your rules and regulations, like any other body. That's what the Supreme Court did after its judgment, which is normal for every proceedings, especially those that touch on the public. The Supreme Court will usually give its own fatherly advice without going into the merits, just speaking generally. And for the political parties, long before now, long before they were even given that window under Section 8414 of the Electoral Act, the principle has always been there. You are an autonomous body, independent of the, what would I call it now? Independent, just like any club. Organize yourself, set your own rules, and settle your own disputes. Don't bog the courts with disputes that are, at the end of the day, family disputes. Yes, you have said that why should the court not interfere when it is the parties themselves that have gone to court? Well, a court does not act at large. Every court, before it can act in the sense that it can entertain a matter, it must have the power to entertain that matter. That is what the lawyers call jurisdiction. If you do not have the jurisdiction to entertain the subject matter, which is, in this case, the subject matter is that of the leadership of the party, irrespective of how you dress it or characterize it, as long as it is about the leadership of the political party, no court has the jurisdiction to entertain it. That was what the court said, and every law student knows that. And but we are talking about political parties here, and that is why, for me, I've always said it, and I will repeat, the courts are even too magnanimous to listen to some of the issues that are brought to them by the political parties. Because the political parties, if I'm to use the word, they have been a disappointment. They are lucky, they are privileged to have been given that particular privilege, power of what? Sponsoring candidates into an election. That power could have been given to religious bodies because every Nigerian is religious. That power could have been given to civil associations. But the Constitution, in its own wisdom, said, you political parties recruit people, candidates for elective offices in Nigeria. And also gave them, impliedly, the function of generating democratic principles and culture. If you look at the American democracy, that you see the way it is, all the principles and ethics of that particular democracy are generated by political parties. And invariably, nothing is said about political parties in the American Constitution. It is just that they've evolved over time to play that role, and the society takes it as such. But here, the Constitution went out of its way to give them those powers and say, give us candidates into elective offices, the president, National Assembly, and state houses of assembly members. That's what it did, in the sense that out of the three arms of government, two of them, very strategic, are to be composed by political parties. But what do we have? We do not have internal party politics. And if we do not have internal party politics, how could we expect politicians to behave? How could we expect them to generate the principles that we would benefit from? And if we're having this sort of paucity of values from our governance system, it's emanates from the fact that the political parties are simply power grabbers and what would I call it now? Wealth seekers, because the moment you get into office, you
Mr.
sit atop.
Pardon me if I may come in, and that would be the bane of, the challenge of political parties and the many litigations that we have, not just of the Labour Party, but of other parties as well. Mr. Odim, I'm curious about your interpretation of the major high point of the judgment on the Labour Party leadership tussle, because it's written in plain English, but your interpretation seems, well, and you're not alone anyway, but I'd just like to present to you a few posers from your interpretation of the judgment. Consequent upon the foregoing, the decisions of the both trial court and the court below recognizing Barrister Julius Saburi as national chairman of the first respondent, that is the Labour Party, is hereby set aside. That's plain English. It's set aside. There's also, in the same vein, the first respondent's cross appeal, in appeal being an offshoot of the same judgment of the court, is hereby dismissed. That is the cross appeal brought by Julius Saburi. It's dismissed. So I'm asking you, why did Julius Saburi present a cross appeal if he is not challenging the position of the Nadi Usman and the caretaker committee on his leadership of the party. The Supreme Court also admonished that officers whose tenures have expired should have the humility to leave office when their tenures have expired. And who may the Supreme Court be referring to in this case, particularly when you consider the series of events trailing the leadership challenge of the Labour Party, when evidently members of the party had rejected Julius Aburi's chairmanship of the party. Mr. Odim.
Now, when you read the entirety of the judgment of the Supreme Court, you would see that so many pages have been dedicated to not being happy with the Federal High Court and the Court of Appeal for dabbling into the internal politics of a political party, leadership tussle and all that. And that is why their lordships of the Supreme Court decided not to fall into the same error of the lower courts. And that's why there is no pronouncement in this judgment as to who is the current national president of Labour Party. The portion you quoted simply says that the decision of the trial court that recognized clearly Julius Aburi as the national president was done in error. The trial court ought not to have dabbled into it. So it is taken as having not been decided at all and having not been pronounced upon at all. Now, the Supreme Court also said the decision of the Court of Appeal that was still made in favor of Aburi, recognizing Aburi as the national president of Labour Party, was also done in error. It is for that reason that the Apex Court has set aside those two decisions. Now, having done that, mostly the courts would go ahead to make its own pronouncement, to make it a final, to put a full stop on the matter, make it clear. But the Supreme Court, if the Supreme Court does that by saying, Aburi, you are the chairman, the national president, or by saying, Nadi Usman, you are the national president of Labour Party, the Supreme Court will be falling into the same error it has blamed the two lower courts of. And that is why the Supreme Court decided to stay away from it and rather gave a directive, because I see this as a directive at the last paragraph of the judgment, by saying, see, before I end, before I leave this seat, let me admonish political party. And when the Supreme Court admonishes, it's a strong point made. That's the apex court in the land. So whether it's obiter or you call it directive, you call it admonition, the Supreme Court has said something in black and white by saying, see, political parties in this country, you must be able to organize yourselves. If you're a leader of a political party, if your tenure has expired, be humble enough to leave. And I think that the Labour Party should work with this. If they take this home, they would then be able to sit down as a political party to ask themselves, when did we give this mandate to Julius Aburi? For how long did we give the mandate to him? If the mandate was for 1 year and it has expired, then Julius himself should humbly step aside. But if the mandate has not expired, then Julius still remains the national president of that party. If it has expired, it therefore means that Labour Party, because it's an internal party issue, should now look at it by themselves and then decide how the next leadership of the political party, should emerge. So that's for me is the simple breakdown and a summary of the decision of the Supreme Court on this very issue.
All right. It's an ongoing conversation, but when we look at it, I think the bone of contention here is that Nnewi Convention. Did it follow the constitution of the party? That is where the real issue is. And if it followed, we now refer to, I think, Section 18 also of their constitution on how to remove a national chairman of a political party. But I must thank you both for coming on the program. Senior Advocate of Nigeria, Sam Kagbo, and Mr. Kemini Udim, Public Affairs Analyst and Legal Practitioner. Thank you, gentlemen. Thank you, sir.
Thank you very much.
Thank you. Thank you for having me.
And we'll now take a quick break. When we come back, we'll get to the next leg of the conversation. Join us again.